I think it's extraordinarily helpful because it's kind of the one time where you have all of the decision-making parties in the same room.
Today, we're discussing mediation for workers' comp in Georgia, and we're going to talk to attorney Sarah Stottlemyer about that on today's episode of Ask the Lawyer. Thanks for joining us, Sarah.
Thank you so much for having me.
So first of all, what is the mediation process for workers' compensation cases in Georgia?
So in Georgia, you can either file what's called a Form WC-100, Request for Settlement Mediation, with the state board, which then you would have a mediator provided by the state board, or as parties, they can go ahead and hire a private mediator and they can have that person work to help resolve their claim.
So how does mediation differ from other forms of dispute resolution in workers' compensation cases like arbitration or a hearing before an administrative law judge?
So we don't have arbitration in workers' comp claims in Georgia. A hearing, you're only entitled to go before an administrative law judge if you have actually an issue where the workers' comp insurance carrier is not doing what they should be doing under the law. So you can't actually get in front of them. There's no way to force anybody to settle your case, right? I have clients all the time who say, great, let's go before the administrative law judge and they'll make them settle. That's simply not possible in Georgia, sadly enough. So a mediation is where you actually get all of the parties together. So you will have the insurance company represented by their adjuster, which is usually available by phone. You will have the defense attorney on your claim. You'll have the injured worker and then the injured worker's attorney. And then you will have the mediator that will help facilitate the settlement of the claim. And they all come together to try and find a resolution. I think it's extraordinarily helpful because it's kind of the one time where you have all of the decision-making parties in the same room.
So you're all working together to try to come to some sort of agreement. Do you have to have an attorney to go to mediation? And if not, should you have an attorney?
So yes, you absolutely always should have an attorney to go to a mediation because you're not going to understand what you're entitled to under the law if you don't have an attorney. It's not like you're going to be able to go through the entire workers' comp statute and try and see where the insurance company is messing up or what you're entitled to in the future. So if you want to get a fair settlement, you should have an attorney when you go to a mediation.
So is mediation mandatory in workers' compensation cases in Georgia, or is it optional?
It's always optional. Unlike some cases, a lot of times when you have personal injury claims or if you're involved in say a divorce proceeding or something, then you'll have court-ordered mediations where the court will say, you all are everybody's being unreasonable. Let's try and get all the parties together in the same room to see if you can find a resolution. In workers' comp, mediation is not mandatory. So it is something that is really good if your attorney will request it, if you've gotten towards the end of your claim. That way you can have also a third party, the mediator, go through and help evaluate your claim as well. And they can reassure you if you have some questions. If you do have a lawyer that you weren't 100% clear on, I think getting another set of eyes on it is very helpful.
So what is the mediator's role in helping people find a solution in these types of cases? How do they operate in this type of setup?
So I am actually a mediator as well. I mediate for a private mediation firm called Bay Mediation here in Atlanta, and I do probably 80% personal injury mediations and 20% workers' comp mediations. My role is to help sit down with the parties and again, help them find a resolution. So I always tell the plaintiffs or the injured worker in the case that while it seems that I may be being hard on you by pointing out holes maybe in your case up to that point or some problems that you may have going forward in the future as far as value goes or that could affect the value of your claim, I promise you that I'm doing equally as difficult challenges to the defense attorney and the adjuster in the other room. So our role is to go back and forth just again as a neutral between the parties to try and help them resolve their claim. I can explain the law to them, but as I always state, I'm not here as a lawyer in any way, shape, or form to represent you. That's not my job. Anything that they say to me is confidential, so I can't be actually called at an administrative hearing in a workers' comp setting to say, were the parties being reasonable? So generally, they're not going to see me again after that day. But my job is solely to go back and forth between the rooms and kind of get everybody to say, okay, this is maybe not what I wanted to do, whether it be paying less or paying more, but this is what's going to be the best possible outcome for both of the parties. So I say that if everybody leaves a little bit unhappy, then it was a successful mediation.
Well, when negotiating a workers' compensation settlement in mediation, what kind of factors are considered?
So you would look at the injured worker's average weekly wage. That's the amount that they were earning at the time of their work-related injury. That results in a temporary total disability rate, which is also determined on the year that they actually suffered their injury. They can also receive temporary partial disability benefits, which is a lesser amount. It's actually 2/3 with a much lower max than what the current TTD max is. So you're kind of looking at what is the exposure in the claim? Is it a 350-week claim? Is it a 400-week claim? Is it a catastrophic claim? And based on the evaluation of what type of claim that is going to create what we call exposure for the insurance company moving forward. So if it's a catastrophic claim, for example, you can't get what's called permanent partial disability benefits, which you would be entitled to if it were not a catastrophic claim. So there are a lot of factors that go in, but basically, how hurt are you? What is your future medical treatment? Because you also have to consider the future medical treatment, such as a Medicare set aside, if you're on Social Security or reasonably likely to become Social Security or Medicare eligible within a certain amount of months. So it's medical treatment, how much you were earning, how your body's physically changed since undergoing the work-related injury, which would result in that permanent impairment rating or permanent partial disability payments, and just kind of how it's affected your life, right? Unfortunately, there's no pain and suffering in workers' comp, but you can kind of increase value if, say, you're a catastrophically injured worker and you're looking to settle, but maybe now you can't mow your yard, or maybe you can't clean your home and you need attendant care. So there are ways to increase the value, but that is kind of the general kind of formula that we look at as attorneys whenever we're trying to figure out what we would either make our settlement proposal or settlement demand for to the defense attorney, and then what we're going to accept to get the claim resolved.
So, Sarah, you mentioned as a mediator, you're acting as the go-between between the two parties. You don't have a stake in the game. You're just trying to reach that agreement. How often do you come to an agreement in these types of cases? And what happens if an agreement is not reached?
So I would say generally on the whole, probably 75 to 80% of the time a settlement is reached at mediation. That's the reason why I'm such a proponent of it, because again, it's getting the parties, all the interested parties in the room, and it's the last time you're really going to have that before you either go to a hearing before an administrative law judge or before you go to a trial. So I would say 75 to 80% of the time, the parties are going to be able to get the claim actually resolved. If they're unable to get the case resolved, it's the same thing that I tell my clients every time we go to a mediation. Don't get upset about it. It's literally going to be the exact same as you woke up this morning. So nothing's really going to change. It's really can only benefit you at the time to go forward with the mediation.
Well, Sarah, thank you so much for taking the time to talk to us today.
Thank you so much for having me.
And that's going to do it for this episode of Ask the Lawyer. My guest has been Sarah Stottlemyer. If you want to ask her about your situation, call the number on the screen. Thanks for watching. I'm Molly Hendrickson for Ask the Lawyers.